connecting contracts for deed to what you already know. In this chapter, you have already looked at the standard real estate sale contract, its provisions, and special variations such as options to buy. In each case, the central theme has been the same. How do we transfer rights in real property in a way that is clear, enforceable, and fair to both parties? A contract for deed continues this same theme, but rearranges the timing of two key elements you already understand: payment and delivery of legal title. Instead of the buyer getting a deed at closing and the seller receiving the full purchase price upfront or from a lender, the contract for deed spreads payment out over time and delays delivery of the deed until those payments are complete. Because of that timing difference, contracts for deed can be very appealing to marginally qualified buyers who cannot obtain conventional financing and to sellers who are willing to act as the lender. At the same time, they introduce special risks and legal issues that licensees must understand to advise clients safely and appropriately. Defining the contract for deed. A contract for deed is also known as a land contract, installment sale, conditional sales contract, or agreement for deed. In Arizona practice, the phrase agreement for sale is often used to describe the same structure. In this arrangement, the seller, the vendor, and the buyer, the vendee, enter a bilateral agreement where the vendor agrees to defer receipt of some or all of the purchase price over a specified period of time. At the outset, the vendee takes possession of the property and begins making payments of principal and interest according to the contract terms. The vendor keeps legal title to the property during this installment period. The vendee, meanwhile, acquires equitable title, meaning the buyer has the right to obtain full legal title when the contract is fully performed. Once the buyer pays the total purchase price and complies with all other obligations, the vendor delivers a deed conveying legal title. In essence, the seller is acting as the lender. Instead of an institutional lender providing a lump sum and taking back a mortgage or deed of trust, the vendor allows the vendee to pay off the property directly over time. This structure allows a buyer who may not meet conventional underwriting standards or down payment requirements to move into the property and build an ownership position gradually. Benefits and motivations for both parties. From the buyer's perspective, a contract for deed can be a path to ownership when traditional financing is out of reach. A self-employed buyer with fluctuating income, a buyer still repairing credit, or someone lacking a large down payment might use a contract for deed to gain possession now and refinance later. During the installment period, that buyer can work to improve credit scores, save additional funds, or build equity through appreciation and principal reduction. From the seller's perspective, a contract for deed can turn a difficult sale into a closed transaction. A property that might not attract buyers who qualify for conventional loans can suddenly become marketable when seller financing is offered. At the same time, because the seller is receiving the purchase price in installments rather than all at once, any capital gain may be spread over several tax years. This can reduce the seller's tax burden in the year of sale and may be used strategically as part of broader tax planning, subject to advice from qualified tax professionals. In Arizona, you may also hear this described as an agreement for sale. Under an agreement for sale, the seller does not give a deed to the buyer until paid in full, so the seller retains legal title throughout the term and the buyer holds equitable title. This mirrors the general contract for deed structure and carries the same practical and legal implications. Vendors' interests, rights, and obligations. During the contract for deed period, the vendor remains the legal title holder and therefore appears in the public records as the owner. This status allows the vendor, in many jurisdictions, to mortgage the property, sell or assign the vendor's interest in the contract to another investor, or become subject to judgment liens and other encumbrances. However, the vendor is also bound by the contract for deed. The seller has promised to convey legal title when the buyer has fully performed, and that promise is enforceable. If the vendee completes all required payments and complies with the contract terms, the vendor must deed the property to the buyer. In addition, if there is an underlying mortgage or deed of trust, the vendor usually remains directly liable to the lender and must continue to make payments to avoid foreclosure, even though the vendee is making payments to the vendor. This combination of power and obligation is important. On one hand, the vendor can still encumber or affect the property. On the other hand, failing to deliver legal title at the end of the contract can expose the vendor to a suit for specific performance, damages, or cancellation, depending on state law and contract terms. Vendee's interests, rights, and obligations. From the moment the contract is executed and the vendee takes possession, the buyer's relationship to the property looks very similar to that of an owner-occupant. The vendee may live in, rent, use, and enjoy the property and may benefit from appreciation or any income the property generates, all subject to the terms of the contract. The buyer also usually assumes responsibilities that would normally fall on a deeded owner, such as maintaining the property, paying hazard insurance, and paying property taxes directly or into an escrow account. The vendee's primary obligation is to make the scheduled payments of principal and interest on time, as well as to comply with any other covenants in the contract, such as maintaining insurance, not committing waste, and complying with zoning and HOA rules. Because the vendee holds equitable title, many courts will recognize that the buyer has a substantial interest worthy of protection, especially after a significant portion of the purchase price has been paid. Legal form and typical terms. A contract for deed, like other conveyance contracts, must clearly identify the principal parties, provide a legally sufficient description of the property, spell out the consideration, and state the terms of the transaction. To satisfy the statute of frauds, it must be in writing and signed by both vendor and vendee. A careful buyer will also see that the executed contract is recorded in the county where the property is located, so that the buyer's equitable interest is reflected in the public record. Typical provisions in a contract for deed include the purchase price, any down payment, the interest rate, the schedule and amount of periodic payments, and any balloon payment due at the end of the term. For example, a contract might require a $10,000 down payment, followed by 59 monthly payments of $1,000 and a balloon payment of $91,000 in the 60th month. The buyer plans either to refinance or obtain new financing to make that final balloon payment and receive the deed. The contract will also allocate responsibility for property taxes and insurance. These payments may be made directly by the vendee or indirectly through an escrow arrangement, where the buyer pays a prorated amount with each installment, and the escrow agent pays the taxes and insurance on schedule. Finally, the contract will define what constitutes default, how notice of default must be given, what cure periods apply, and what remedies are available to each party. Some contracts include a strict forfeiture provision that allows the vendor to declare the buyer's interest terminated and retain all payments if the vendee falls behind. Others incorporate more foreclosure-like procedures. Default, forfeiture, and remedies. When the vendor defaults, such as by refusing or failing to deliver the deed after full performance by the vendee, the buyer may have several remedies. In many jurisdictions, the vendee can sue for specific performance to compel delivery of the deed or seek cancellation of the agreement and damages. Because the vendee has been paying and has equitable title, courts are often willing to enforce the buyer's rights when the vendor fails to perform. Buyer default is more complicated and varies from state to state. In some areas, default under a contract for deed is treated primarily as a breach of contract. The vendor may cancel the contract, keep the payments already received, and evict the buyer through an unlawful detainer or similar proceeding. In other jurisdictions, especially where the buyer has paid a substantial portion of the purchase price, courts and legislatures are more inclined to treat the buyer's position like that of a mortgagor in default. In those states, the vendor may be required to use foreclosure procedures, and the buyer may be granted safeguards such as an equity of redemption or a right to cure. The harshness of strict forfeiture is easy to see. A buyer who has paid $95,000 of a $100,000 purchase price could, in theory, lose both the property and the $95,000 in equity by missing a single payment if the contract allows immediate forfeiture and the law permits strict enforcement. Modern trends in many states have softened this approach, especially when the buyer is near the end of the payment schedule. Courts may require foreclosure instead of simple forfeiture, ensuring that any surplus from a foreclosure sale after paying costs and the remaining debt goes back to the vendee. Other states may give the vendee a statutory right to cure the default by paying the past due amounts and resuming the contract. Without a specific statute, courts that follow this modern trend often base their decisions on equity and fairness. They look at the amount paid, the buyer's conduct, the seriousness of the default, and the extent to which forfeiture would unjustly enrich the vendor. Practical risks and usage guidelines. Because a contract for deed looks simple on paper but can become complex in practice, it carries significant risks for both parties. For the vendee, a major danger is that the vendor still holds legal title and has the power to encumber the property without the buyer's knowledge. The vendor could take out a new home equity loan, fail to pay an existing mortgage, or allow judgment liens to attach to the property. If the lender forecloses or a judgment creditor forces a sale, the vendee's equitable interest may be jeopardized, even if the buyer has made every payment under the contract. In some states, a contract for deed is enforced entirely under general contract law rather than foreclosure law, meaning the buyer may not have the benefit of statutory foreclosure protections, redemption periods, or court oversight. The vendor might attempt to declare a forfeiture for relatively minor infractions, putting the buyer at risk of losing possession and payments with limited recourse. For the vendor, the primary risk is giving up possession to a buyer who has made only a small down payment. If the vendee fails to maintain the property, causes substantial damage, or abandons the property in poor condition, the vendor may have to spend considerable money and time to repair, retake possession, and clear title. Because the contract is usually recorded, the seller must also address the recorded interest when trying to resell or refinance the property. To minimize these risks, prudent parties should observe a few simple guidelines. They should use a real estate attorney to draft or review the contract, especially in states without standardized or association-approved forms. They should understand how local courts treat contracts for deed, whether as pure contracts or as mortgage substitutes, and how defaults are handled. They should use professional escrow and title services to handle payments, taxes, and recording. They should record the contract properly so that the buyer's equitable interest and the seller's continuing rights are clear in the public record. And they should carefully review the impact of any existing financing, including due on sale clauses, before entering this type of arrangement. When properly structured and understood, a contract for deed can be a powerful tool to solve financing problems and create opportunities. When poorly drafted or misused, it can lead to serious disputes, lost equity, and costly litigation. Review summary. In this section, you learn that a contract for deed, also known as a land contract, installment sale, conditional sales contract, agreement for deed, or agreement for sale, is a bilateral agreement where the vendor finances the buyer's purchase by accepting installment payments and retaining legal title until the price is paid in full. The vendee takes possession and gains equitable title with the right to receive legal title at the end of the contract. You saw how this arrangement can help marginally qualified buyers who cannot obtain traditional financing, and how it can benefit sellers who want to facilitate a sale and potentially spread capital gain over time. You also studied the vendor's continuing power to encumber the property, the vendee's responsibilities for payments, taxes, insurance, and maintenance, and the importance of recording the contract to protect the buyer's equitable interest. You examine typical payment structures, including down payments, periodic principal and interest installments, and balloon payments, as well as provisions governing default, forfeiture, and remedies. Finally, you explored the modern legal trend away from harsh, automatic forfeiture and toward foreclosure-like protections when a buyer has built substantial equity. And you learned practical guidelines to reduce risk for both parties. Discussion. Why is a contract for deed particularly attractive to some buyers? And what is the main trade-off they make by choosing this method instead of conventional financing? Answer. It is attractive because it allows buyers who cannot qualify for a conventional loan to take possession and build an ownership position over time. The trade-off is that they give up immediate legal title, accept the risk that strict forfeiture may be enforced if they default, and rely on the vendor to keep underlying liens current and title clear. How does the vendor's ability to mortgage or encumber the property during the contract term create risk for the vendee? Answer. Because the vendor still holds legal title, the vendor can place additional liens on the property or default on existing loans. If a lender forecloses, the vendee's equitable interest may be wiped out despite the buyer's faithful payments, leaving the buyer with little or no protection unless statutes or court decisions provide foreclosure-like safeguards. Why are modern courts often reluctant to strictly enforce forfeiture provisions when a vendee is near the end of the payment schedule? Answer. Strict forfeiture in those circumstances can result in severe injustice, allowing the vendor to retain both the property and a large portion of the buyer's equity over a relatively minor default. Courts concerned with equity and fairness may require foreclosure procedures or give the buyer a right to cure, so that any surplus value after paying the remaining debt and costs can return to the vendee. What practical steps can both parties take to reduce the risks associated with a contract for deed? Answer. They can use legal counsel to draft or review the contract, rely on standardized forms where available, understand local enforcement rules, use escrow and title services to handle payments and recording, and analyze existing financing to ensure that due on sale clauses and lien priorities are understood before committing to the arrangement. Closing remarks. The contract for deed is one more example of how flexible real estate contracts can be when parties need creative solutions. Like options and other specialized agreements, it reshapes the traditional timeline of payment, possession, and title transfer. For a real estate professional, the goal is not simply to know that these tools exist, but to understand how they shift risk, how they are enforced in your jurisdiction, and how to explain those consequences clearly to clients. As you move forward in this chapter, keep connecting each new contract type back to the core principles of offer, acceptance, consideration, capacity, and lawful purpose. And remember that the best deals are those where parties understand what they are signing before they pick up the pen.